The main issue is whether or not the information was stale or too attenuated with the safety bulletin. In the Commonwealth's brief, they cite Commonwealth versus Keene, which stands for the proposition that police can have reasonable suspicion just based solely on a safety bulletin. That case is different from our case at hand because in Keene, that case.
But the argument isn't based on the safety bulletin alone, right? I mean, the argument is based. Your argument, it seems to me, turns on getting us to agree that the stop occurred before before there was any interaction whatsoever between the defendant and the police officer. Because once the defendant says, if there hasn't been a stop, the police officer comes up and says, hey, can I talk to you? I hear you might have a firearm. And the guy reaches for his waist when the information in the bulletin is the firearm was in his waist. Isn't that enough for him to pat frisk?
No, I think we have to take one step further, though. And that is the safety bulletin is too attenuated because it's 15 days old. He doesn't have any other information.
So it's irrelevant? Is that your argument? It cannot be considered whatsoever? It wasn't even the basis for the question?
I'm sorry, can you repeat that?
Well, I mean, I don't understand the argument. Well, maybe I do, but I'm trying to pin you down to it. Are you saying that the bulletin, because it's 17 days old, is completely irrelevant and cannot be considered whatsoever in connection with what happened?
I'm not saying it can never be. No, that's not what I'm saying.
Okay, so if we can consider it to some degree, it can at least be the basis for the question, hey, I heard you had a firearm on you, at which point he then reaches for his waist.
No, what I'm trying to say, Your Honor, is when the officer has that information from the safety bulletin, well, it can be a factor, it should not be a main factor in this issue because it's so old.
Let's assume for a moment that the safety bulletin didn't exist. And the officer approaches the defendant and says, I heard a rumor that you have a weapon in your waistband. Is that okay, or is that a seizure?
No, so when the officer says, can I speak with you for a moment? You can obviously say, you know, the defendant says, yes, I can talk to you.
Okay.
That is fine. And
okay.
Next.
And let's look at the observations that followed from that question. The officer essentially sees him reach for his waistband, sees something that looks like it could be a gun protruding from his waistband, right?
I don't believe in the seizure of that day he sees a firearm. He saw the firearm in the safety bulletin.
But he saw a bulge, right?
He saw something in his waistband, his pants, yes.
Right.
Well, he saw, according to his testimony, which I believe is credited by the judge, that he was pulling up his pants fairly regularly and there appeared to be something bulky in them. Right?
Yes. So I would like to kind of compare the two cases. In Commonwealth versus Martin, for example, this is a little bit slightly different fact paradigm. I like to kind of use it. In Matter, what it says is they agree that it's common individuals to adjust their pants while getting out of a car. Well, I understand and agree that this is just an individual walking down the street. I would argue that issue should also apply here. Because what happens is the officer comes up to him, says, oh, can I talk to you? Yes. No. Then he says, I understand and heard that there might be a firearm issue with you. At that point, I'm arguing that he should have been seized there because the defendant takes a step back, looks like he's going to leave or something. It's not clear within the testimony what he was actually thinking that day. Then he goes for his waistband.
Oh, but you're arguing that there's a seizure when he asks the question?
So when the officer says, I heard something about, I'll get the correct words. He says, I told him that I heard that he has some issues in the neighborhood involving a firearm.
And that's a seizure. Your argument is that's a seizure.
No, the next step. which is when he takes a step back and has to leave.
Well, but the officer didn't do that. Your client did that.
Correct.
I mean, the seizure has to be based on something that the officer did, right?
So what is the seizure you're saying is the pat frisk?
No, right before the pat frisk.
What? Okay, precisely when? What was the action that constituted the seizure?
So after the officer says, "I heard you had some issues in the neighborhood with a firearm."
Yeah.
The next step after that, the defendant takes a step back.
How can the defendant's action constitute a seizure by the officer?
Well, because then the next step after that, the officer says, "Stop, put your hands in the air, I'm going to pat frisk you."
Okay. So the officer, well, I think we can all agree that the officer's statement, "Stop, put your hands in the air, I'm going to pat frisk you," is a seizure.
Correct.
Okay, and the officer did that based on his observations, right? He saw a bulge. He saw him adjusting his pants. He saw him blading. He saw him stepping away. And the question is whether that is that in combination, based on the officer's training experience and his awareness that this defendant had in the not too distant past been described as carrying a firearm in his waistband, whether that is adequate to constitute reasonable suspicion. Right? That's a question that we have to decide, right?
Yes, but what I think the trial judge at that day had put too much emphasis on the safety bulletin.
Well, okay, but that's not binding on us.
No,
we take the findings of fact. I think we've all now at this point. I can't speak for my colleagues, but I think we are all in agreement that the inventory of facts that we have is common, and if we don't put as much weight on the safety bulletin as you suggest, the motion judge inappropriately did, we still are at the point where the combination of factors that I've just recited either does or does not constitute reasonable suspicion. And speaking for myself, I guess I'm having a hard time understanding why it would not.
The reason why it would not, Your Honors, I don't mean to beat around the same bush over and over again. I know your time is valuable. I don't believe the safety bulletin was attenuated. It was too stale. The officer did not have reasonable suspicion. It went beyond a threshold inquiry.
Of course, it went beyond. We're not talking about the safety bulletin in and of itself. The safety bulletin at the very end of a very long string of other factors that suggest the possibility of a firearm, including a heavy object that's in his waistband, and a bulge, and his blading away. And then you add the fact that he is reported to recently have had that. It's just the icing on the cake, if you will, not the foundation.
You don't contest the basic facts of that the judge recites of the encounter itself. You don't contest that the police officer said first a question along the lines of, I hear you have an issue with firearms, or that you might have had a firearm. You don't contest that he stepped back, and you don't contest that he reached for his waistband. Am I right about those things?
No, I don't question the facts of the motion to suppress hearing or the judge's findings.
All right.
If there are no other questions from the panel, I would rest of my briefs, Your Honors.
Thank you.
Thank you very much.
Oh, before Attorney Spavento, before you leave, I just want to address one housekeeping matter, and that is, as you have seen, the Commonwealth submitted a motion to transmit an exhibit from the trial court.
Correct.
Attached to that motion is what appears to be a photocopy of the exhibit itself.
Correct.
Rather than transmit, and I'll have the same question for the Commonwealth, but Do you have any question about the accuracy or the faithfulness of that photographic reproduction of the exhibit?
Oh, no, Your Honors.
These days, the getting things out of trial court clerk's offices can be a little more challenging than usual because of the pandemic. And even if we were not under the pandemic circumstances, I would ask, I guess, whether you would have any objection to our acceptance of that copy as a supplemental element of the appendix.
No, Your Honors. I spoke with the Commonwealth, and we both had difficulty with the trial court getting stuff as well. So this is what we came up with.
Okay, so then we will accept that exhibit as a part of the record and move on from there, rather than reaching out to the trial court ourselves for transmission.
No, anything to make your job slightly easier. So.
And yours as well.
Thank you.
Okay. For the Commonwealth.
Good morning, Your Honors. May it please the court, Monica Delatorre, on behalf of the Commonwealth. I would also like to acknowledge the trial prosecutor, Kevin Bergen, who is watching via the live stream. The Commonwealth respectfully requests that this court affirm the denial of the defendant's motion to suppress and affirm the defendant's convictions. I'm happy to start elsewhere, but I will start with the defendant's first issue in the brief, which is the motion to suppress issue. I believe my brother and I are in agreement when the seizure occurs, which is when the officer orders the defendant to put his hands up and do a pat frisk. All of the actions that had occurred beforehand are not a seizure, as consistent with Commonwealth versus Mata being the most recent case, including the fact that he had told the defendant that he had heard that there were some issues in the neighborhood involving a firearm. At that point, I would point to that there are 5 different facts that support the officer's reasonable belief the defendant was carrying an unlicensed firearm. The first one being the safety bulletin that had been issued beforehand. I would argue even without that safety bulletin, there was reasonable suspicion here. The defendant was seen pulling up his sweatpants, which were weighed down by a heavy object. There was an object that was seen swinging within his sweatpants as well, and his gait was off duty.
Well, surely the police can't just walk up to anybody who's pulling their pants up and pat frisk them, right?
Sure, there needs to be reasonable suspicion for that.
Right, but I mean, it seems to me that the action of having an heavy object in your pants or pulling your pants up is at the end of any list. There has to be some much more sound reason for the police to be approaching and believe that that's a firearm before there can be a pat frisk, right?
Well, I think there are additional facts here that point that there is a firearm. We have the safety bulletin where the defendant is wearing similar clothing where he is hiding a firearm. The officers, in terms of when they were mentioning a firearm, the defendant began to step backwards and attempted to distance himself from officers. And the defendant, before the officer actually began speaking with the defendant was being evasive to the officer. And this is important because the officers and the defendant had a friendly relationship where they, I think, believe the testimony of the officer was that they spoke almost daily and were friendly. And so that behavior was odd and unusual. So there is definitely additional facts here that allow the officers to at least go up and question the defendant. Again, that doesn't require reasonable suspicion, but the pat frisk does. In addition to those facts—
He's walking down the street at 10:30 in the morning, right?
Mm-hmm. Correct.
And the next thing you know, he's being pat frisked.
Well, I would disagree that the officer just pat frisked immediately, and he did stop.
He asked one question.
He first asked if the defendant would be willing to speak with him, and he then stated that the defendant said yes. The question back was what's up, and then the officer then stated that he had heard that the defendant had issues in the neighborhood regarding a firearm. The stop and approaching the defendant does not require reasonable suspicion. I would point the court to cases like Commonwealth versus Shane S., which is a 2017 case, the 92 Mass.
If he didn't have the bulletin, Ms. Delatorre, if he didn't have the bulletin, did he have reasonable suspicion?
I believe that there would be enough here without the safety bulletin, but the safety bulletin buttresses and supports the facts here.
I mean, he goes up and he says, hey, I hear that, let's assume there's no bulletin, as Justice Green asked the question of your brother. And he goes up and he asks a question about firearms. The guy takes a step back and reaches for his waist. That's enough without the bulletin?
I believe without the bulletin, it's enough where the defendant is seen having an object swinging in his pants, where his pants are being weighed down, where the defendant's being evasive, where he's normally had a friendly relationship with officers, and where the officers knew that he had convictions of ammunition possession and was a known gang member as well, so they had known that he didn't have a license to have a firearm. I do think it is enough with the safety bulletin, though I do think the safety bulletin, as I said, helps, showing that the defendant had access to firearms, showing that he had worn this type of clothing before in the past in order to hide a firearm as well. So I would suggest here, in the totality of the circumstances, the stop and frisk was lawful, stop and pat frisk was lawful, as there was reasonable suspicion that the defendant was carrying an unlicensed firearm at that time. I'm happy to answer questions on the second issue if there are.
Well, let me just ask, it's clear that we have the authority to vacate. You concede that the charge is duplicative. It's clear that we have the authority to vacate it. What would be the reason for us not to do so?
Well, I do agree that this court has the discretion to consider the issue. I would say that this isn't a duplicative conviction, to the sense of that the defendant was not sentenced on the ammunition conviction and that it was placed on file.
What is I'm just trying to understand, what would be the reason? What would be the interest that would be furthered by leaving it on file?
Well, I mean, procedurally, defendants cannot appeal from a guilty file. It's generally the
I understand that, but it's clear that we have the authority to act on what we all agree is a duplicative conviction. What is the interest that would be furthered by our declining to do so and leaving it on file?
Well, I just mentioned this up to the court's discretion. I do think that there is case law of not appealing from a guilty file. I can inform the court though that.
But counsel, maybe I can put a finer point on the chief's question. Why is the Commonwealth opposing this?
I was just going to inform the court that if, depending on the court's disposition, the Commonwealth does intend to file a malpros on the ammunition charge. Yes.
Okay, I mean, look, I understand your respect for the details of a procedure. There are times when I find myself drawn in that direction, but this seems to me not to be one of those compelling occasions to rest on procedure. I'm at a loss to see any benefit from leaving that hanging around.
Understood, Your Honor.
Okay. Thank you both. That concludes.
And we are going live.
Okay.
On the record.
The next case on our list for hearing this morning is case number 2019 P751, Commonwealth versus PHILLIP DURANT, also known as UMAR MUHAMMED.
Good morning. May it please the court, my name is Andrew Smith and I represent Mr. Muhammad. Today I'm asking this court to overturn Mr. Muhammad's convictions because of what was an impermissible and illegal closing argument. While my brief focuses on three specific errors, today I would like to begin with what I think is one that may merit some disentangling. The numerous occasions in the closing, the Commonwealth states boldly, the victims had no reason to lie, or the victim had no reason to lie. Those statements are coupled with what I refer to as rhetorical questions. So further, maybe, a handful of thoughts later, the district attorney will then say, why would she lie? She has no motive. What has a ring of truth to it? Who has a motive to lie? Again, later. Now, what motive does complainant one have to lie? What does she gain by coming in here and talking about all of these things that happened to her?
Mr. Smith, you're aware that pointing out that a witness has no motive to lie is okay, right?
I would say it's not okay when it's coupled with rhetorical questions asking the same thing.
Well, why? I mean, the motive to lie is at the heart of it. There are certain rhetorical questions are problematic, but not when they are simply another means of framing the same point that the victim or the witness has no motive to lie. There were a series of cases back, I can't remember now, 10, 15 years ago. And I wrestled with this issue a little bit, having to do with the difference between motive to lie and a suggestion that a witness is more credible because of their willingness to be subjected to the rigors of cross-examination. And motive to lie is okay, saying that they are more credible because of their willingness to be subjected to cross-examination goes across that line. And it's a subtle distinction, but it's an important one.
Well, I think that certainly DAs across the Commonwealth are aware of kind of dancing on the line. When they make it a statement, when a district attorney says the victim has no reason to lie, on what basis do we believe that statement? I would suggest.
Well, isn't it an argument? I mean, it's an argument, right? You know, the defense counsel stands up first and suggests the victim is not telling the truth. Here are all the reasons why the victim's not telling the truth. The Commonwealth then has to be able to rebut that. And it seems to me in making that argument, the Commonwealth must be able to say, ask yourself, what motive does this victim have to not tell the truth? It cannot be, and it's not, because as Chief Justice Green pointed out, you know, there are some earlier statements that suggest there's a problem with no motive to lie, but he took care of that in a case that he wrote. I think it's called Headley. Helberg, yeah.
And Ramos was the bookend to that. And the SJC picked up that theme and has articulated it beyond that initial development. Helberg and Ramos together cleared up some confusion that was created by a pair of cases, Ribeiro out of the appeals court and Beaudry out of the SJC. But the point is that if anything, the rhetorical question that asks what motive does the witness have to lie in this context is a means of introducing an inventory of the evidence at the trial. As you know, and as you correctly recited in your brief, the prosecutor in closing has every right to marshal the evidence in support of an argument. And pointing out that there is an absence of any evidence suggesting a motive to lie is simply a part of that process, isn't it? Then
again, what do we do with a case, Scandier or Haberic, which says, making the assertion that, in effect, the Commonwealth's evidence is uncontroverted?
Well, that's a different argument. That's not.
That's where this argument's going. They have no motive to lie. That's a statement that there was no evidence controverting that. No, that's the danger of the rhetorical question.
No, it's not. One is talking about evidence. The other is talking about credibility, about motive. And this argument is about what's going on in the head of the witness, right? You say you can't say what motive does she have to lie, but our case law says you do. Now, there is this place on page 83 where the prosecutor went one step further. What does she gain by coming in here and talking about all of these things that happened to her that may be different in kind, but again,
the question with the issue with the rhetorical question is when you ask a rhetorical question on this issue, who's supposed to answer it?
The jury.
And I just as a matter of argument, I have trouble seeing who
It's the jury.
is supposed to answer that question other than the defendant.
It's
And
the
in
jury.
fact, I'll even go one step further, counsel. Not only is it clear to me that when you ask that rhetorical question, the jury is to answer it, but that's exactly what the Commonwealth's lawyer said 2 sentences above the one I just read. That's the question that's important for you to talk about and to analyze.
Right. Ask yourselves.
But by analyzing it, who would they be looking to have provided evidence for?
They are asking themselves to, on the basis of the evidence at the trial. It doesn't imply an obligation on anyone's part to put something forward, but it points out that there is no indication that the defendant has any motive to lie. In a setting where the defendant has suggested that the witness is not telling the truth.
Well, and perhaps we've kind of lost one of the threads here, but the issue ultimately is are we shifting burdens to the defendant? I mean, that's the danger of the rhetorical question. That's the danger of...
You're asking that in a rhetorical question, I'll just point out.
Of course. But who answers that question? And we do it commonsensically. I mean, in normal conversation, it's not unusual to ask a question.
And the reason for that is it's a manner of argument, counsel. It's a manner in which people speak. And the Commonwealth's lawyer, doesn't the Commonwealth's lawyer have the ability to speak to the jury in the way that people speak?
Well, I don't think we can make that blanket statement. I mean, certainly we're aware the Commonwealth can't say, what does she have to gain from coming in here?
Well, I don't know about that.
And one of the dangers of something like that is it is commonsensical to. I mean, it's not crazy for a juror to say, why would this young girl come in here and subject herself to this? That's the danger of saying it. Is you're inviting the juror to think something that's, I think most people would be comfortable with. What
Beaudry said about that is that it suggests that the jury should give more weight to the witness simply because the witness is there, right?
That's correct.
Mr. Smith, if I could follow up. If we conclude on the record before us, having read the transcripts, that the questions posed by the prosecutor were asking the jury to consider the answers to those questions, do you agree that that would not shift the burden of proof to the defendant?
No, I think it still does, because it's not, I mean, they're obviously asking the jury to consider the question, but where does the jury look for the answer? Habarik, all it says is, if it doesn't shift the burden, it's not impermissible. Here we have a question of, when you ask a jury to contemplate this issue of she has no motive to lie, why would she lie? Again, the question is directed obviously to the jury, but where is the jury expected to find that answer? That's the burden of proof question.
Which, if any, of these statements in the closing were the subject of an objection?
He made a general objection that they were vouching. And then he said, this
isn't vouching.
Closing.
I'm sorry?
He said, this closing goes beyond a normal closing, or something, obviously not specific.
Okay. So that the claims that the arguments that you're making on burden shifting, that certainly is not preserved, and the motive to lie was not preserved. That's not vouching. I'm just trying, and it's hard for me to tell what might be preserved by that kind of a broad, ambiguous comment at the conclusion of the argument.
I believe we've discussed this in another oral argument, and sometimes at trial, the objections are not what you would read about in an objections book.
Well, I understand, but you also understand that it makes the trial judge's job immeasurably easier if they are specifically and timely made, and it makes your job on appeal immeasurably more straightforward if you're reviewing for prejudice as opposed to substantial risk.
Well, and thank you for trying to bail me out. And but the one thing I would say is, I think his objection to the vouching is these statements from, or are these statements from the district attorney saying she has no reason to lie. Because again, going back to what I suggested earlier, if I say the evidence demonstrates that she has no motive to lie, that to me is very different than saying she has no motive to lie. Because my authority is,
when it's framed in terms of a rhetorical question, ask yourselves, on the basis of what you've heard this morning or today, who has the motive to lie?
Well, that's the danger of the question. We know who has the motive to lie.
If that was what the objection was to the statement, she has no motive to lie, she has no motive to come in here, I think the lawyer needed to identify those statements. And in fact, in Beaudry, it was important to the court that those statements had been identified and responded to by the judge. And, you know, the court in Beaudry made a point about the fact that you need to object so the judge has that opportunity to address those things. And here, that objection doesn't talk about no motive to lie, and that objection doesn't talk about no motive to come in here. So it's a bit problematic, I think, to say it's in that veiled statement at the beginning about she seems to be vouching for the credibility of her witnesses. What do you say?
I would suggest it's a stretch as much as it is problematic. But certainly, we don't know what he means by this goes beyond a normal closing. So we are somewhat stuck from that perspective of, I took the vouching to mean assertions by the DA. I apologize, I've just expired.
Well, you have not.
All evidence to the contrary, you're still talking.
But
okay.
Thank you for your arguments.
Have a nice day, everybody. Thank you.
We'll stay with us while the Commonwealth argues. Attorney Armstrong.
Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. I would like to acknowledge the trial prosecutor, Laura Montgomery, as well as the victims and members of the family who are watching this argument live via the live stream. I would first like to start by answering Chief Justice Green's question about the objections here. There were 4 objections during the closing arguments. The first came during the closing argument when the defense attorney stood up and objected in the middle and said that the prosecutor was disparaging or spoke disparagingly about his remarks. That was overruled by the judge, and then closing continued. And then at the end of the closing, the defense attorney lodged 3 specific objections again. The first was to vouching. The second was to facts not in evidence relating to the picture of the defendant's penis and the skin pigmentation. And the third was that the defense attorney objected based on the prosecutor charging the jury. Those were the 4 objections that were preserved. On appeal, those apply to the vouching claim, to the claim about a disparaging
Well,
comment.
you know, I mean, how specific do they really have to be? You know, vouching, I suppose, has unfortunately, a particular meaning in the way that our cases have addressed this. But he says vouching for the credibility of, saying there's no motive to lie. What does she have to gain? Isn't that arguing about the credibility of the witness in a sense that's vouching?
Maybe we could twist those words to make
Well, I
that.
hope I'm not twisting them. I'm really just asking the question.
Then my answer would be no, because if you object to the statement that witness has a motive to lie, or you object based on credibility, then you have to state that as your basis. Because without that, then the trial judge can't weigh your objection and then analyze the relevant facts. And also the prosecutor wouldn't be able to make an argument about that. If a defense attorney objects and says vouching, and then on appeal says, oh, well, that vouching actually meant credibility, it meant rhetorical questions, it meant the prosecutor stepping over the line, that's not the purpose of an objection. So,
well, but even arguing credibility is not vouching in and of itself. My understanding of vouching always has been that it is argument suggesting that the prosecutor has independent extraneous knowledge outside of the trial evidence that the jury should accept from him as his personal or her personal endorsement of the credibility of the witness.
I've spent hours with such and such a witness, and let me tell you, she's telling the truth.
Precisely.
Which is very different from what we have routinely said is not only perfectly acceptable, but to be expected that a prosecutor may argue from the evidence why a witness should be believed.
Precisely. And to take that one step further, that's exactly what we have here. You have
well, with one exception. I mean, as Justice Englander pointed out in his conversation with Attorney Smith, at one point, at least one point, the prosecutor's formulation of no motive to lie said no motive to come in here and lie, which starts to stray in the direction of what we've said is not okay, right?
Correct. And I would, so first, the specific word she said was, I would suggest to you she has no motive to lie. What does she gain by coming in here and talking to you about all of these things that happened to her? That's a little bit different than Your Honor's recitation of it, where it says, so I would say that what the prosecutor said is walking up to the line, but doesn't cross over that.
Well, nothing to gain by coming in here is, it implies at least, or may begin to imply that that coming in here is something that would require compensatory benefit, right?
Mr. Armstrong, the problem with that is that it suggests that the victim should be believed in a sexual assault case because she has come in and subjected herself to cross-examination and told an embarrassing story in front of or in a public forum. And why isn't this particular statement suggesting exactly that to the jury?
Well, I think because you have both, you have this one statement, so this one sentence out of an almost 20-page closing argument, and it's couched by the evidence. It's coming directly in after examples of what the victim testified to, and it's just a rhetorical question that, to Chief Justice Green, your point about compensatory motive,
Compensatory benefit. I understand your concern, and I think if the prosecutor if that had been her theme throughout the closing, we would be in a different situation. But when she only uses the word, what does she gain, or only uses that statement once, I don't believe that crosses over into. Well, but it's not just the compensatory benefit. And I just, that's not a formulation you find in the cases. I just made it up as we're sitting here. It is that the concept that there is some burden to be overcome in order to, as Justice Kinder just said, come in and reveal these embarrassing personal experiences in front of a public audience and subject yourself to the rigors of cross-examination, as some of the other cases have observed. It is the idea that it's not easy to do what she's being asked to do, and in order to do it, one might think that she would require some benefit to overcome that, but because she doesn't have that, you should believe her.
Well, but I think the argument went further than that, and didn't just say what does she have to gain and then stop and then leave that to the jury to decide. The prosecutor went further on to say, look at the relationship that the defendant created with this victim. He looked out for her. He, mentored her and tutored her, and look at all the things that she testified to and her, recitation of things. If the prosecutor had just said, what motives does she have to lie? What does she gain by coming in here, and stops, then I think it's a little bit more ambiguous and goes towards the point of potentially leading more credence to the witness. But what we have here is the prosecutor makes that statement after just going through the sexual assaults on that specific victim, and then goes through all of the victim's testimony to kind of detail that relationship. So when you have this statement couched in evidence that was properly before the jury, I think it's just another form of the rhetorical question of who has the most.
Well, it's really unfortunate. And he doesn't say it once, he says it twice. He uses the exact same formulation, gain by coming in here. He says it with respect to each witness as he goes through each witness's evidence. And it is identical to the language used in Beaudry. It is not different. So I understand your argument, and I give you credit because I think you're right that there are other aspects of the argument directly around it that have to do with, not just she doesn't like this guy, but she did like this guy. He was a mentor. He was someone who was good to her. What does she have to gain by biting the hand that fed her? But it's the coming in here part of it that it almost looks like a nervous tick. And it's unfortunate.
I understand Your Honor's point, and just to clarify, your question was when he said, "I assume you're talking about the trial prosecutor."
Yes.
Yes. Sorry.
That's okay.
It's a
no,
woman,
that's
right?
okay. I just wanted to clarify just to make sure we were talking about the same person.
Yep.
And so on page 83, where we are talking about the first victim, JJ. We've kind of discussed at length that statement. With respect to saying that to victim AY, that goes kind of to my brother's second argument about the disparaging comment, which wasn't a disparaging comment, but more discussing the victim's demeanor when she's approached with that question from trial counsel about how lying comes easily to her. So if you look at that, the victim puts that, right in front of the jury. She says, I'm not here for any, other reason, for any ulterior motive. I'm here because I don't want this to happen again. And because I want to tell the truth and I want you to hear my side of the story.
And in fact, in her case, that was that really echoed her testimony in response to that line of examination by the defense counsel.
Precisely, Your Honor. And that was exactly my point, is that was all testified to by victim AY, and it's all properly before the jury. So when, testimony is rooted in evidence, the prosecutor can marshal that in closing, which is precisely what she did here. And Justice Englander, to your point, when you have, perhaps by saying,
she actually uses the word "sit here." And as I'm sitting here right now, that's what AY said when she was confronted on cross-examination. She talks about, I don't have a reason to sit here and lie to you. It's an interesting point, counsel.
Precisely, and I think it's very important that the jury are going to determine credibility. They're instructed on that extensively, and the trial judge instructed them here. And so when you have that testimony from a victim, that's all evidence for the jury to consider. That's absolutely proper fodder for closing examination. And I think a good closing argument would focus on that. And because when you have this case of two young victims testifying and the defendant testifying, it's a question of credibility. And that's what both closings here revolved around and what closings in those types of cases typically do revolve around.
Do you want to say anything further about the specific argument on appeal by the defendant about the preserved objection to the argument that the trial prosecutor disparaged that exchange, that conduct by the prosecutor?
Sure, Your Honor. Thank you. What I would say is that wasn't a disparaging remark about trial counsel's performance. To read it that way, I think misunderstands and misconstrues the record, specifically when you look at how the judge responded to that objection and said, I didn't hear it that way. I heard it as speaking towards the witness's demeanor and her reaction. And the prosecutor follows up with that and says, yes, that was precisely what I was about to say, focus on the witness's demeanor to that question. And that is entirely proper. As I just pointed out, that's entirely proper fodder for closing argument because it was testimony that was elicited by the defense attorney and that came in through no objection. So it was properly before the jury. So it was entirely proper for the prosecutor to focus on that. So even though that objection is preserved on appeal, there was no error because there was no disparaging comment about the defense attorney, the trial counsel's performance. It was all focused on the victim's reaction and demeanor and what she said in response to that. And then I will just briefly close on the final argument of my brother being that the prosecutor asked the jury to convict on insufficient evidence. This claim was not objected to below, so it was reviewed for a substantial risk. And this simply was not what the prosecutor did. Trial counsel for the defendant stood up and said, there's no tangible evidence here of any sexual assault. And in response to that, the prosecutor said, well, of course, there's no tangible evidence. You have the victims and the defendant who said they did this alone. They did this with no supervision. There was no one in the house, nobody else around. And the victims came forward years later. So of course there's going to be no physical evidence. There's going to be no forensic evidence. It's going to be one person's word after another. And even more, the judge instructed the jury explicitly on the burden of proof that the Commonwealth carries, that the jury are to determine credibility and they're the finders of fact. So because that wasn't objected to, there was no substantial risk. And even more, the prosecutor's argument was not in error. So therefore, there could be no substantial risk. If there's no further questions.
Seeing none.
We are live and on the record.
Okay, the next case on our list for hearing this morning is case number 2019 P1473, the Commonwealth versus Michael Doherty. And just as an advisory, following the conclusion of the argument in this case, we will be taking a brief morning recess. Attorney Scapiccio, you may begin.
Thank you, Your Honors. My name is Rosemary Scapiccio, and I represent Mr. Doherty in these proceedings. May it please the court. I'd like to get through three issues, if I could, this morning: the closing argument issue, the jury instruction issue, and the adjutant issue. I'd like to start with the closing argument issue, understanding that the appeals courts very infrequently reverse a conviction based on a closing argument alone. But I think that this closing argument is particularly egregious. And I think in the 30 years that I've been doing this, it's probably the most egregious closing argument that I've ever been involved in. The prosecutor on 5 separate occasions made comments that were either unethical or unlawful based on all of the current state of the law. First, he told the jury to ignore our entire theory of the defense because it was garbage. And he said something to the effect of, don't buy that. That's more of the same garbage. With respect to the alleged second victim, Mr. Werner, he commented that Mr. Werner was being forthright with the jury because he told the jury about his convictions and his problems with the court system, when in fact, the prosecutor had filed a motion and had been successful in excluding the fact that Mr. Werner had a robbery charge against him and a restraining order against him in which he was the first aggressor. Then the prosecutor commented on the fact that Mr. Doherty didn't call 911 and claimed specifically that you won't see the defendant calling 911. And the Commonwealth seems to suggest that somehow that's appropriate under Commonwealth versus NASA. The problem with that argument is that, of course, in the NASA case, the defendant testified, and here Mr. Doherty did not. The fourth issue that
I don't understand. I guess on the 911, you stand up in your closing and you make a point about why didn't the prosecution's witness call 911. You make that point more than once. Isn't what Commonwealth said in response responsive to that?
No. I mean, well, of course, it might be responsive, but it's unlawful.
Why is it unlawful? You think this is a comment on pre-arrest silence?
Absolutely.
Under the circumstances?
When he says that you won't see the defendant calling the police, absolutely, it's a comment on pre-arrest silence. How is the jury supposed to take it any other way? What specifically the prosecutor said is you won't see the defendant calling the police, shifting the burden of proof to the defendant to suggest that he had a burden to do something in this case.
No, he is simply talking, sorry, counsel, he is simply talking about the facts of the case. You have said, how come, I can't remember the name right now of the witness against your client, the first Uber driver, how come he didn't call 911 then? And he's responding to that, and then he says, and take a look at the defendant's records. You won't see him calling 911. Now, It seems to me that that's a perfectly reasonable response to your argument. It's simply saying, she's saying, my guy didn't call. Take a look at her guy. He didn't call either.
Except the defendant has a Fifth Amendment right to remain silent. The witness doesn't.
That's the opportunity to...
In pre-arrest context, I'm not sure of that.
I believe, Judge, that it's clear that Mr. Doherty doesn't have to do anything. He doesn't have to call the police. He doesn't have to report the crime. He has an absolute Fifth Amendment right to remain silent.
What his actual actions can be commented on, counsel. The evidence in the case can be commented on. And
not when it goes
what
to
the Commonwealth was doing.
Judge, I respectfully disagree. I do not believe that you can shift the burden of proof to a defendant. I do not believe that you can comment on the defendant's pre-arrest silence without some instruction from the court saying it's improper. And even the judge thought it was improper under the circumstances. And because the judge understands that you can't comment on a defendant's pre-arrest silence. The defendant and the witness do not stand in the same footing when the defendant is being charged with a crime by the Commonwealth.
It is not true categorically, counsel, that you cannot comment on pre-arrest silence. But in any event, I understand your argument.
Not under these circumstances, Judge. Not with this language of you won't see the defendant calling the police, because that shifts the burden of proof to the defendant. And in addition, another comment that the prosecutor made is that when he was trying to explain why the first Uber driver, whose name was Blanco, had so many inconsistencies, the claim was that the trial attorney had frightened him. That's the reason. Because of the aggressive cross-examination, the trial attorney.
When you made your objection to that statement, if you stopped the tape right then, I can understand why you thought that. But as the argument continued, it appears to me in context as though he was talking about that Blanco was in a frightened state of mind as these events were occurring, about which he was the prosecutor was commenting.
Well, Judge, that's the argument that the Commonwealth made. I don't necessarily believe that, because specifically. What the prosecutor said is, the defense attorney is a great cross-examiner. You saw her come in here and cross-examine. She was great at what she did, but I'd say she frightened him.
No, he didn't say she frightened him. He said he was frightened. And then when after the objection and after the prosecutor continued with the argument, the fright that the prosecutor was describing was the fright arising from the circumstances of the altercation.
After he had been corrected by the trial judge, yes, that's what he said. But that's not what he said, nor what he meant when he first said it. He said that the witness was frightened by the trial attorney. That's what he said. And the trial attorney was doing her job when she's cross-examining the witness.
You were the trial attorney, right?
I was.
Yeah. But I don't think he referred to the trial attorney. He referred to the fact that you saw him being cross-examined, but I would suggest to you he was frightened.
Judge, what specifically he said was?
I'd say he got frightened.
Right. But what he said is the prosecutor improperly argued that this particular witness got frightened. And that's in the context of saying that the defense attorney was a tough cross-examiner. What is the jury supposed to infer from that situation? Of course, the jury is going to infer that in this situation, somehow I frightened this witness. That's but
when the argument, I mean, I understand that you took it that way when he said it, but after following the objection, as he continued that argument, as he continued to draw out his purpose in making that argument, he said, Mr. Blanco, he's confused. He's uncertain of how things happen because frankly, he doesn't look like the kind of guy who walks around with a gun, right? He's not nervous. He's nervous. He's frightened. He's afraid. That's what the prosecutor said.
But that's after there was a sidebar conversation where the prosecutor was.
No, there wasn't. There wasn't a sidebar. Sorry, there wasn't.
Judge, in this case, when I objected to the prosecutor
using that language, the court sustained your objection. You said, I'm doing my job. The court said, okay, and he moved on. There was no sidebar at that moment.
Judge, at this point, when he is saying that I'm frightening a witness, he's commenting on.
He wasn't saying that. I know you took it that way, but the jury...
that, Judge, but that's what the jury thought he was saying. That's what I believe the jury thought he was saying when he's, because if it was just a state of mind, Judge, then why comment on the cross-examination? Why comment on how good the lawyer is on cross-examination? Why do that if this is what the situation is? And I would suggest when you put it together that way, certainly you could see it both ways, Judge. I will agree that you can see it as the prosecutor fixing it and saying that he was frightened that night, and that's why he made inconsistencies. But when you couch it in terms of the defense attorney being a good cross-examiner, and then I'd say he was frightened, it's a completely different ball of wax, I believe. But I understand the court's position. I understand how you could see it both ways. I don't agree. I think that the jury understood exactly what the prosecutor wanted to convey under these circumstances, and that's what he did. And the last thing that the prosecutor did is say that Doherty is looking for a pass because he raised self-defense. And I'd suggest, again, an affirmative defense is not a pass. Self-defense was an appropriate avenue for Mr. Doherty in this case. His entire theory was premised upon the fact that these individuals were looking to rob him that night and that they were the first aggressors. And I would suggest when you put all of those issues together, that there's no doubt that closing argument infected the entire trial and should result in the reversal of Mr. Doherty's conviction. All of the issues were objected to. Many of them were sustained by the trial judge. One of them that was not sustained by the trial judge is also a preserved objection that I'm saying should cause the reversal of Mr. Doherty's conviction. The second issue that I'd like to move on to is that the adjutant issue, judges, and that's that we have Mr. Werner, who is the second Uber driver on the stand. We have a situation where Mr. Werner is alleged to have been one of the first aggressors. What the trial attorney, or what I was trying to do at the time, Judge, was to be able to cross-examine Mr. Werner with the fact that he could have been the first aggressor in this case. We had given notice to the Commonwealth that we wanted to do an adjutant defense. They understood, and it wasn't a situation where the Commonwealth was saying this never happened. No, they were saying it wasn't relevant.
Let's assume for the moment that Werner was the first aggressor. How does that, the assaults against Werner were not the assaults that led to any of the convictions that are the subject of the appeal, right?
Right, but it goes to the credibility in terms of what's happening here, Judge. So would the jury have decided things differently if they had known?
No, but the adjutant goes to self-defense, not to credibility, right?
Right, because Mr. Werner, in this case, and Mr. Doherty were engaged in an altercation where Mr. Blanco was also engaged. It was two against one.
You need to, in order to support your adjutant claim, you need to lay out for me more clearly than you did in your brief or in your reply how it is that that the defendant's defense against Werner justifies his assault against Blanco.
Because Blanco is holding Mr. Doherty while Werner is assaulting him. They were in it together. They were working together. That was the whole theory of the defense. The theory of the defense was that these two
One
people,
assault took place in the taxi cab, in the Uber, before Werner became a part of anything, right? That's
Yes.
one of the charged offenses.
yes,
So anything relating to Werner as the first aggressor is irrelevant to that assault, correct?
not necessarily, because I think that in
Okay,
the
explain that to me.
So when you're deciding who the first aggressor is, Doherty's position is that both Werner and Blanco were working together to drop him off at this vacant lot so that they can rob him.
What
But at
is
the
the
time-
evidence? I'm
at
sorry,
the-
counsel, sorry.
At the time,
Can I,
go ahead.
what is the evidence as to when Werner was first seen by your client? What's the evidence on that?
When he was first seen by my client,
When did your client first become aware of Werner's presence?
I believe when Werner was, after Werner and Blanco had a conversation in the side-to-side car, and after Werner had driven the other alleged victim, Mr. Blanco, to where Mr. Doherty had allegedly dropped off Mr. Blanco's car. That's when
After
he
the
became
first
aware.
assault had concluded, in other words.
No, because there's still, at that point in time, there's still an altercation. According to
How is there any evidence, I'm sorry, counsel, how is there any evidence in the case that your client was aware of Mr. Werner before the first assault?
That's not the point. The point isn't that he was aware of Mr. Werner.
It sure seems like it to me, at least with respect to the first assault, because with respect to the first assault, there can't be any adjudant evidence that's at all relevant if he didn't know that Werner was there.
So what I'm suggesting is if Blanco was working together with Werner and the two of them are planning to rob my client, which was the entire defense in this case, they were planning on robbing my client. Anything that each of them does to suggest that they were the first aggressor is important in this case. That's the
Not
theory.
with respect to the first assault, if he has no knowledge of anyone other than Blanco, if there's no evidence in the case that your client has any knowledge of anyone other than Blanco before the first assault, then the adjudant evidence isn't relevant to the first assault. How can it be?
But Judge, well, we can agree to disagree. Certainly it's relevant to the second assault. Certainly it's relevant to Mr. Werner kicking my client in the head, admitting that he's kicking him in the head, admitting that he is the first aggressor in this case, admitting that
he's aware of Werner before he assaults Blanco the second time.
Well, it depends on whether or not
I
you
would
think.
agree that then your argument makes more sense to me.
Yes, and if you believe Werner, then Blanco, according to Blanco, my client was already out of the car running around chasing him. According to Werner, my client was sitting in the back seat of the car when he pulled up, and then there's an altercation of 2-on-1. That's what he said happened. But the point of the matter is, the way that the trial judge decided the adjutant error is the problem. What the trial judge said, first of all, is that Werner's Fifth Amendment right trumps Doherty's Sixth Amendment right to a fair trial, which I think is unconstitutional. And secondly, she shifted the burden of proof by saying, if you want to prove this for adjutant, whether it's the first offense or the second offense, if you want to prove it, then you have to then call your own witnesses to prove up the adjutant issue. You can't prove it by asking the witness who's on the witness stand that the Commonwealth doesn't dispute these things happened about these crimes. And what I'm saying is, how do we know that Werner would have denied his involvement in the robbery? How do we know he would have denied his involvement in the restraining order? Had he admitted those things, there would have been no burden on the defendant to call any witnesses. And that shift in the burden of production and the burden of producing evidence in this case is what's wrong with the instruction.
I certainly agree that if you're entitled to put in first aggressor evidence, you're not confined to the witness's answer to the question. I see that your time is up. You can rest on your brief for what remains.
Thank you, Your Honor.
Thank you. Attorney Shorey.
Good morning, Your Honors, and may it please the court. If I can just briefly address that adjutant issue first and foremost, I think it is that the judge's ruling was correct as to both the first and the second incident. The only evidence admitted at trial was that Mr. Werner attacked the defendant after the second attack on Mr. Blanco.
Is that critical?
I think it is.
Critical. Why is the timing critical? If at the time of the second assault on Blanco, he was aware that Werner was there, the defense is the two of them are working together. Okay. And so why is it irrelevant at that point assuming he hits Blanco first, he knows Verna is there. Why can't he put in evidence to the effect that one of these people has first aggressor issues?
Because knowing that he's there isn't the standard. I think the standard is both that self-defense was at issue and that the issue of first aggressor was at issue. And Verner's presence didn't raise the issue of first aggressor. So neither of those.
Why? It was enough for the judge to allow a self-defense instruction.
Well, it really wasn't. The judge actually changed her mind on that and said, after having given the instruction, said, I erred. I never should have given that instruction. He clearly isn't entitled to self-defense. She then kind of backtracks and doesn't decide necessarily whether he's entitled to it on the second offense or not. But I think it's clear that he was not entitled to that instruction, even though the judge did ultimately give it.
With the evidence that was adduced at trial, your position is that there wasn't sufficient evidence from which the defendant could argue that they were acting in self-defense?
That's my position. I think the evidence was very clear. There was never a dispute that Verner struck the defendant. He testified after the defendant used a racial slur against him. He said he punched him. He said he punched him hard. He then said he body slammed him and he kicked him in the head. There was never a question that Verner attacked him.
The jury can't infer from the fact that the two of them showed up that they lied about whether or not they knew each other. Or at least there's evidence from which one could reach that conclusion, right? There's evidence that they used one of them used the other's name during the altercation, right?
Yes. So, might a jury have a reasonable doubt about whether they knew each other or had some prior contact or whatever? The jury could.
Okay. And when is the evidence as to when the two of them were seen side by side in a car? That came from a Massachusetts Massport witness, right? A Massport police officer. When was that in relation to when all this occurred? I get from the briefs somewhere that the jury could have at least inferred from that testimony, if not explicit, that they were seen side by side. Their cars were seen side by side before the incident occurred. Am I wrong about that?
Your Honor, I'm not sure I'm prepared to address that issue in much specificity.
It seems to me to be a pretty important point where you're arguing to the effect that there was no basis for the judge to charge on self-defense.
Well, I don't think it's an important point because both parties said they were in a car together driving to the second location following the defendant. There was no doubt they were together. But the idea that it was a planned robbery, the evidence that the defendant didn't present a defense. The only evidence the defendant introduced was his own medical records. So that was the only evidence in support of the self-defense. These other two people were both present doesn't create a self-defense. Even if the evidence was that they knew each other, that doesn't create a self-defense. The defendant didn't present any evidence that he couldn't evade the conflict.
And they lied about knowing each other to the police?
Well, again, I don't know how that raises.
They had some kind of communication even before the first occurrence, Well,
I don't know what the evidence. I don't know of any evidence of that.
No, that's why I asked the question. I should know the record better, counsel, and I apologize. But my question was, were they seen side by side before the first occurrence with Blanco?
There was surveillance video, Your Honor, I think that was introduced by the Massport officer that you referenced that apparently showed two cars side by side. I think it was speculative and part of the defendant's claim for reasonable doubt that this was something that happened beforehand. But there wasn't. I don't think even if that were the case, if the jury were to speculate these two cars side by side, that was these two people, I don't think that's enough to raise the issue of self-defense.
I suppose given the whole series of events of the night, that would be kind of difficult because he picked them up in North End, drove them to Charlestown, and then came to Southie. So when would he have been with Verna before that? Okay, that's helpful. I understand a little better.
But let me just pause for a moment because instead of spending so much time arguing about whether there was a basis for the self-defense instruction, the self-defense instruction was given. So if let me just ask you, Attorney Shorey, are you concerned that if there was a basis for self-defense, then the adjutant evidence against Verna should have been admitted?
I'm not, because the issue of first aggressor still was not at issue. The only
let's
evidence
take it up on that score instead of arguing whether or not the self-defense was raised because self-defense was administered.
Well, the instruction was given, that's right. But the jury still would have had to have a sufficient basis to find it in order for the adjutant evidence to be admissible. But
your point is that even if it were a basis for self-defense, it doesn't go to self-defense because of the circumstances of the assault.
That's right. And I think this, so I will address that point. The first aggressor evidence is that the only evidence that's admitted at trial is the testimony of Blanco and Verna, that the defendant, when Blanco got on the phone and was talking to 911 and started to describe the defendant attacked him. After that, the only evidence from both those people is that after that point, Mr. Verna got involved. So I really don't think there's any basis from which the jury could plausibly have found otherwise. Again, the evidence introduced by the defendant about his injuries didn't go at all to when that occurred.
No, but the defendant isn't limited, of course, to the evidence that he himself puts forward. He can also argue inferences from the Commonwealth's evidence.
Right, but that's what. And that's why I just addressed the evidence that came from the Commonwealth. So I think, let me just lay out
so that you can knock it down. My understanding of the best case, as I understand it, for the argument that Verna's first aggressor status would bear on self-defense against Blanco, and that is that he believed, with basis in the evidence, that he was the victim of a robbery orchestrated and planned by Verna and Blanco in concert, and that while Blanco was calling 911, he thought that the best way to extricate himself from that situation, in anticipation of Verna's likely attack against him, would be to go after Blanco. That, as I understand it, is the Commonwealth's adjutant theory.
The defendant's adjutant theory, but the evidence that there was this planned armed robbery and that was the first aggression was wildly speculative. It wasn't affirmative evidence in the record that the jury could find, and so I think that's the crux of it. There had to be evidence from which the jury could have found that the first aggressor issue was in dispute, and it simply wasn't.
Well, that sounds like the same argument you were making earlier.
Yeah, I get it. We've got a number of other arguments, and frankly, the defendant's primary focus during her argument was on the closing. Why don't you respond to some of those concerns?
Okay, so if I can get to the whether the defendant was frightened by, the prosecutor's argument that Mr. Blanco was frightened by at the time of the offense. I think it is clear, given page 128 of the transcript, that that's what he's referencing. But I think we can dispense with that issue a bit more quickly, just in the fact that a prosecutor is permitted to argue that a witness came across a certain way or credibility may have been at issue because of the skillful attack or skillful cross-examination, and the jury can account for that.
Really? That's interesting. You didn't say that in your brief.
So I did.
You did.
Well, I did.
You think is there a case that says highlighting the quality of the cross-examination and then saying the person didn't respond well because of the quality of cross-examination is acceptable argument?
Commonwealth versus DeVoe, 34 Mass Appellate Court, 9, page 14.
Mr. Shorey, to follow up on that point, why isn't the prosecutor's follow-up comment that I think he got frightened? Why isn't that an expression of a personal opinion related to the credibility of the witness?
Well, I think the evidence about what had happened suggested he was frightened, and it was certainly a reasonable basis for someone to be frightened. So I think that's, the prosecutor is allowed to argue from the evidence, and where an Uber driver early in the morning is driving someone home as part of his job, and he's attacked viciously by his rear seat passenger, and I think that's a fair argument for the prosecutor to make.
Assume for just a minute that we interpret what was said as a comment on the victim having been frightened on the stand in the courtroom. If we assume that, then isn't it fair to look at the prosecutor's comment as a personal opinion regarding the victim's credibility?
Well, I don't know if I have the exact words off the top of my head, but he points to the contrast to the jury to view the contrast between Mr. Blanco and Mr. Verna in terms of their personality and demeanor and things like that. So I think, that is the crux of what the jury's role is, to look at witnesses on the stand and evaluate their credibility and make determinations based on that. So I think that's entirely fair argument, and not outside the bounds of any trial where the jury has to decide between witnesses, and the litigants have to point to which testimony should be believed.
How about the reference to the defense theory of the case and argument related to that theory as garbage?
So, I acknowledge that this is not a great practice to use the phrase garbage there, but I think
not acceptable, is it?
Well, so I think if the most direct case on point is the Lewis case that I cite, which says that a prosecutor can refer to an argument by the defendant as a sham. And so I think, whether it's technically improper or not, I think is, that case would suggest it's not. And I think, especially in the circumstances of this case where it was such a wildly speculative claim that there was no basis for in the record, I think the prosecutor should be allowed to address that pretty forcefully. I'm not saying I would recommend using that phrase. And the more important point in this circumstance, this exact case, though, is that the judge sustained the defendant's objection and struck that testimony from the record. I will just note, I apologize. I think there was an issue with the time. So I think this is showing more time than just in the interest of candor than what I actually have left.
I think that's probably right. I think you probably have about 2 minutes left.
Okay. If I can address the 911 call with the comment on the defendant's failure to call 911 in those couple of minutes left. I think, as Justice Englander, you pointed out, with the defendant, it's important to note here the issue is a little different when it's pre-arrest silence and post-arrest silence. But I acknowledge there is a general rule that there's little probative value from addressing pre-arrest silence. In the circumstances of this case, I do think the defendant kind of argued that it was the reason why the jury could have reasonable doubt that Mr. Blanco did not initially call 911. Well, Mr. Blanco did initially call 911. The 911 was in evidence, and the timing of that 911 was that as soon as he got out of his car, as soon as he escaped the attack by leaving his jacket behind and grabbing one of his cell phones as he got out of the car, he called 911. And when the defendant then says that's his failure to call 911 is the reason why the jury should acquit the defendant, the prosecutor is allowed to respond to that. Additionally, the evidence, the defendant's claim that he was the victim of a planned robbery by these two individuals, it would be natural in those circumstances for someone to call 911, and that's exactly the circumstance in which pre-arrest silence can be admitted against the defendant. That was unequivocally the defense raised by the defendant, and I think it was fair for the prosecutor to raise that issue in response to the clear claim by the defendant.
Can I have a question on an issue that hasn't been touched on yet, and that's the jury instruction with respect to, it's just factual really, with respect to count 3, the defendant says there should have been an explicit instruction that the existence of the racial slur alone is not enough. And you respond to that by saying, well, that's not an element of the case. It's within the judge's discretion as to whether or not they talk about something that might be a limiting factor to that. But factually, was there any objection or request for this particular, well, take them in the reverse order. Was there a request for this instruction? Was there an objection when it wasn't given?
There was, well, so the factual question gets a little confused because the defendant definitely requested the instruction as to count five. Yes. That's the written request. Then during the oral argument on that point, the defendant does mention count 3 and count 5. The judge says, okay, I'll give that instruction. But then the judge says, defendant, I plan to give the instruction here, and only mentions it as to count 5. And the defendant says, okay, thank you, judge. And so then really, I think there's a good question. The defendant didn't put the judge on notice as to specifically what he was requesting.
As to this particular objection. And then the Commonwealth, the prosecutor says in closing, that's not enough just to have the slur. Says it explicitly very early on, as I recall. Okay. That's
right. And I think the elements of the offense listed by the judge, that intent to intimidate is required, preclude that possibility as well. If there are no further questions, I would rest.
Thank you both. A lot here. The case is submitted.
Those almost entire, 60 years on this planet. There are 3 arguments I raised in my brief. I'd like to take them in turn. The first argument.
Well, before we get too far along, Attorney Green, I guess I want to make the observation that the hearing examiner's decision in this case predated 2 fairly significant cases out of the SJC. One is DOE 496501, which you cite fairly extensively in your argument, and the other is DOE 23656. I think I have all those digits correctly. I may have missed one. I really wish they would use pseudonyms instead of these numbers. It makes it impossible. But particularly in 23656, didn't the SJC impose a requirement that in any instance where there is internet dissemination required, that the hearing examiner's decision make an explicit determination of why internet dissemination is warranted in this particular case?
That's correct. So DOE 23656 lays out that there needs to be detailed and specific findings that track the regulations. And in this case, as my third argument lays out, there were no findings to support the internet dissemination.
Well, and in fairness to the hearing examiner, there were no findings because the SJC had not made it a requirement at the time that the hearing examiner issued the decision in this case.
There wasn't an explicit requirement of the 3 steps, but within the regulations, there had to be a finding of dangerousness such that internet dissemination was required or realistically served public safety. In this case, as my third argument also states, the dangerousness finding was not made by the hearing examiner. And so the hearing examiner knew going into the decision that there had to be a finding of moderate risk of reoffending, moderate degree of danger. And in this case, there was no finding of moderate degree of danger.
I guess my point is that the level of detail and the level of specificity required in the decision was, while you can say that it was inherent in the law prior to that time, it's not terribly surprising that it wasn't present in this particular case. I don't think that there is any particular controversy, at least not in my mind, about the fact that this needs to go back to the hearing examiner to address the points that the SJC articulated after he issued his decision. Or I don't remember this he or she.
Well, why don't we, before we prejudge that, why don't we let her argue a little bit more, Judge Green? Because I'm not utterly convinced of that.
Well, I was trying to invite her to go straight to the other things that we would need to tell the hearing examiner on remand. But if you're not yet persuaded,
well, the issue on the issue of publication, it's a prospective ruling. The case that you're citing, of which number I will not remember, but it's prospective, and so it's within our discretion whether to send it back or not, right, Counsel?
Right.
That is correct. There is discretion. However, this is not a case where the underlying facts are so clear that it dictates that internet dissemination is warranted. So it is a remand case that needs to go back to the board for further discussion and detailed.
Why do you say that? I mean, your client, there are two components to the three, but one, I know what you're going to say, and I kind of get it. There's three components to the case against your client, right? One is a series of domestic assaults against one live-in girlfriend, which required her to go to the police at least twice, which resulted in convictions. And then another one is a pretty extensive criminal record which preceded that. And then the third is this event where he was accused of rape, but it was then dismissed, right? So why is that not enough for a conclusion that, yeah, we need to tell the public about this guy?
It's not enough because the actual offending behavior itself are not, the details of those offenses are not such that it raises public safety concerns. This was an anomaly in Mr. Doe's life. It was during a period of severe alcoholism, as is throughout the record. This was not a member of the public.
It appears that alcoholism was not limited just to the time period in question. I think he had 4 OUIs starting 20 years earlier, right?
That is correct, but that even goes to show that he is not at risk of reoffending because he had been drinking for decades. This was truly an anomaly period of his life that these offenses occurred. I would go back to say that the public safety.
It's something that it seems to me is open to at least a question, but it's not crystal clear that for us in the first instance to conclude, at least in my mind, that internet dissemination is required.
The record does not support it as it is now, and the decision certainly does not touch on it. If this case were to be remanded back to the board, which I think it does, I would also ask that the board pay attention to another issue that I raised in my brief, if the panel is okay with me going to my first argument. I would like to move to that argument. Okay. So aside from DOE 496501, which requires those 3 elements, and the internet dissemination has not been touched in this case, which requires a remand, there's also another issue here that I believe that the hearing examiner needs to address. Factor 2 was applied in this case, and Factor 2 is being applied in a lot of cases, and it's not justified in many cases. And this is one of those
compulsive elements.
Exactly. The repetitive element was applied in error because the hearing examiner found that the 2014 case that was dismissed, she found in her findings, she stated, I cannot find that this happened. But yet she then used that as the touchstone to apply Factor 2 entirely. Without that 2014.
Assume that she was wrong to say that she could rely on it at all. Wasn't there still repetitive conduct? There's 3 separate criminal acts.
There were 3 separate offenses for which there were convictions or there were charges laid out, but they do not qualify as repetitive acts as the research shows. The research I'm referring to is the scientific articles that support Factor 2. They state that there has to be some sort of intervening circumstances. There has to be charges, convictions, somebody addressing
the situation. Not what the regulation says, is it? The regulation certainly allows, and some would argue compels, a conclusion of repetitiveness from 2 acts.
It says to be considered separate, there must be time and opportunity between
the episodes. That's on the compulsive issue. Are you arguing on compulsive or on repetitive?
Right now it's repetitive, and which was found, but it was found in error.
Yeah, but that language about time and opportunity goes to compulsiveness, doesn't it? Not to repetitiveness?
It does not. It goes to repetitiveness. My argument is that for repetitiveness, there are more than one offending behaviors, but those offending behaviors have to be intervened by charges, by the person being confronted, by convictions. It cannot just be time and opportunity to to reflect on somebody's wrongdoings. And that's what the hearing examiner applied in this case.
Are you crystal clear? I mean, all of the reason why time and opportunity to reflect after being confronted would be important goes to the inability to control the impulse, which repetitive is in and of itself simply it would seem to me a numbers counting. I mean, I'll go back and check the regulations, but
well, I'm looking. The reg is in your brief, isn't it?
Yes, it is. The reason I separate the two and I don't say that just time and opportunity to reflect is in the case of Doe 22188, Justice Milkey, I believe, said that it is not just an opportunity for moral reflection. There has to be more to find compulsion. Compulsion has to be a psychological compulsion or obsession. And that's what was defined as compulsion. And that's why I separate the two.
When you cited, with all due respect, when you cite to Justice Milkey, and I have the highest regard for him as a colleague, but he was writing for himself when he said that, right?
That's correct. That was in a concurrence.
So there is no current published authority that holds the proposition that you're relying on.
There isn't, but there should be, because these are two elements and the hearing examiners apply them as if they are one finding, and they say repetitive and compulsive, and that's not it. The reason this is such a high risk factor and it carries so much weight with it is because it truly is a psychological issue that somebody has within them that they actually cannot stop offending. And that's not how the hearing examiners are applying this. They're applying this if somebody has 2 episodes of offending. That's it. Factor 2 is applied. Factor 2 is a high risk factor. It has so much weight to it that the hearing examiners. Is your argument
going to compulsion or to repetitiveness? That's what I'm struggling with. I thought I heard you say you were arguing repetitiveness. Now your argument is about compulsion. Which one?
No, my argument's about both, and in my brief it's laid out both. Repetitive was found in error by the hearing examiner. Compulsion was not found at all, not discussed. So that's my argument, is that factor 2 was applied in error because repetitive was found, but it was erroneously found. Compulsion was not even discussed. So they're 2 separate elements, and in this case, neither one of them was applied appropriately.
Well, the compulsion not even being discussed, there is, you would say there's no time and opportunity between offenses because there were 3 offenses where there was no challenge in between them, even though they were separated by about, I think, a 6-month period, right?
They all occurred within 3 months. But okay. Yes, you're right.
So that's your argument is because there was no charge with any of them, compulsion can't apply under the reg?
My argument is that repetitive cannot apply under the regs. Compulsion is my argument is that compulsion is a psychological element that needs an expert and it needs an evaluation because factor 2 carries so much weight under the regulations.
Your argument is you can't use factor 2 without an expert.
Not if you want to find compulsion, and so no.
Before you run out of time.
I didn't read that in your brief. I have to say that's news to me.
Well, when I referenced Justice Milkey's concurrence in 22188, that was what I was referring to, because in that concurrence, the Webster dictionary, I believe, that was used was a psychological compulsion. And I submit that the hearing examiners are not
Is there any other area where we say the hearing examiners are incompetent to reach a conclusion without an expert? I thought that we don't do that. I think there's case law that says that there doesn't have to be expert testimony on any of these factors.
If it goes beyond the scope of the hearing examiner's knowledge, then it is.
But that's not an answer to my question. Is there any other case law that suggests that there must be an expert in order to apply a factor?
There is not case law that specifically cites a specific factor and says you need to have an expert to apply this. However, there are specific cases that have been found that an expert is necessary. I would submit in this case, I'm sorry.
I'm sorry, just before you run out of time, I had one question related to your second issue. We, of course, are used to seeing hearing examiners ascribe certain weights to the application of factors, and your argument is that that was not done here. But is there any authority that requires a hearing examiner to ascribe certain weight to factors rather than simply saying they apply?
At this time, there is not a case that specifically requires it. And the cases that I bring before your court, I keep asking the court to please publish a decision, because I think that it will prevent many of these issues, because we don't know what the hearing examiners are doing behind the scenes with the factors. They're blanket application of factors, and we need to have weight so we can figure out how they reach their conclusion. DOE 68549 stated that they have the discretion to consider factors, but it doesn't require that weight is assigned. And I think that there needs to follow-up case where weight is required underneath each factor so that a reviewing court can make a meaningful review of the decision.
Thank you. Any further questions?
No.
I think I might have. Hang on for a moment. Well, perhaps not. I think, thank you, you've done a nice job.
Okay, thank you. We will leave it there. And counsel that the case is impounded, but it is the argument is open to the public. Please avoid any reference to the impounded material, particularly the names of the parties or their status. You can refer to them by their status in the case, mother, child, etc. With that, you may begin.
Thank you, Your Honor. May it please the court, Attorney Deborah Dow, and I represent the mother in this case. Mother had a right to both informed settlement and an advised settlement in this case, and she was afforded neither. And that's the crux of this case and the crux of my argument. Mother had significant disabilities for which her attorney was aware of these disabilities, and mother's argument is that she was not afforded effective assistance of counsel with respect to both the settlement of this case as well as the colloquy that happened with respect to this case.
Is there anything, so let me see if I can ask the question better. Where would I go in the record to find anything from the attorney as to his communications with his client on this subject? Does he have an affidavit?
There was only an affidavit that was provided to the court as he was withdrawing. That's my recollection. There was nothing else provided to the court with respect to this case by counsel or trial counsel in this case.
Wasn't there some discussion in the colloquy itself? Both with your client, between the judge and your client, and between the judge and counsel?
I believe that the discussion rendered around the fact that he had read to her the documents that were provided that morning.
And also that he asked the judge asked the mother whether she had discussed this with her counsel, correct?
She did ask that, yes.
Okay.
Yes.
So, sorry, go ahead, sorry.
I'm sorry, go ahead, I didn't mean to interrupt.
No, I thought Justice Green had another question.
No,
if
I
he
don't.
Doesn't,
No.
I do. So, you know, ordinarily where we see in the criminal context, an ineffective assistance claim, the case law says that we want to hear from the attorney. And, you know, there are explicit assertions in the record here about what the attorney told your client that it could be material, but we have nothing from the lawyer on any of those subjects, right?
Right, and I think I can't underscore enough, you know, how difficult it is to obtain information from an attorney, you know, in accordance with adoption of Aziza. how difficult that information is and how hard it is to come by, especially when you're looking at a potential ineffective assistance claim. I think
that's inherent in ineffective assistance claim everywhere. The point is that in order to make a claim based on what did or didn't happen, we need to have evidence to support that.
Well, we do. I mean, there is obviously, mom came back very quickly in this case, I might add, to say that this was not what was represented to her. I think that it's undisputed at this point that she went to the DCF office, said, you know, now is the time for my mom to have custody in accordance with what this attorney has told me, only to be turned away and then to come back to court within just a few days on motions. So I do think that there's, you know, while there's not direct statements by counsel necessarily, I think that there certainly is indicia that that information was not provided to mother to the extent that she came back quickly.
But the judge held a hearing, right?
The judge had a colloquy. There was
no
I'm
talking about on the motion for relief.
Yes, there was a hearing. Yes.
And you know, again, we look to even though this is a civil matter, we look to the criminal counterpart for analogies. And the judge here who conducted the evidentiary hearing on the motion for relief was the same judge who conducted the colloquy, had the opportunity, not just the colloquy, but also the previous C&P trial, had extensive experience with the mother, and was in a position to assess credibility. As a reviewing court, it places us in a very questionable posture to be asked to overturn what is essentially a question of credibility, disregarding the mother's assertions by the motion judge.
Right. And I realize it's the same judge, but at the same time, I think that there was evidence that was presented at the motion for relief and that hearing that had not been previously presented.
Understood, but the motion judge took that up. I mean, again, in the criminal context, we extend particular deference where the motion judge on a new trial motion is the same as the trial judge for their ability to sift through both the significance of the new information and also the credibility of that evidence as well as the evidence at trial.
And I would suggest to the court that this isn't just solely an issue that rises on credibility as far as, you know, what one witness is saying, but there are a series of facts that are underlying this. And the facts are, and I don't think that that's been disputed, the facts are that mother had a disability. Mother had a significant disability. Mother had a fourth grade reading level disability.
Right, but the judge in the colloquy, I mean, this was an extraordinarily detailed colloquy. And in that colloquy, the judge elicited the fact that counsel had read to mother line by line the terms of the stipulation, every single element of the stipulation, right? So her reading ability, the judge also was able from her responses to various of the questions, including her demeanor, to ascertain her comprehension of what it all meant. Now you may suggest that mother didn't understand it, but the judge was there. We were not.
At some point, some of this information has to overwhelm the fact that somebody was just physically present and listening to this information. And I think we're at that point. I think, you know, with the information that was subsequently provided, that's where we are. We are saying that at this point, the information that was not revealed, and let me just go back a second. At some point, if the attorney is saying that he's reading aloud to the client, then I think I'm out of time. Then I would suggest to you, then that question should have raised issues in and of itself. And I'm unfortunately going to
but I'm not sure where it leads you. Okay, I can accept the first part of it, but I'm not sure what that means. Okay, so his client has very serious reading disabilities, okay? If we accept that, and he knows that, and it's his job to represent her to the best of his ability, what more needs to be done other than to sit with her, explain it to her in detail, read it to her out loud? What more would you expect of her counsel? How is it ineffective?
So I will say that, first of all, I think it's clear that to ask for a brief continuance would have been prudent in this case. Having an understanding of the level of mom's disabilities, to ask for time to review it adequately and thoroughly, not just the day of the hearing when you have 60 to 80 pages of documents. I don't know exactly how many there were, but there were at least, I think 9 different documents. In addition to that, if he had any concerns about mom's understanding, or to the extent that she understood, whether he was reading aloud or whether he thought that she understood the writing, then he had the opportunity to avail himself of a guardian ad litem for those purposes. To make sure.
What does a guardian ad litem add to just having a lawyer who is your lawyer on this case? I'm not sure what a guardian ad litem, it seems to me, just adds another person in the room. It's his job to make sure, it's his job. And he has professional responsibility to make sure that she's knowingly and voluntarily advised, right?
He does have that responsibility.
Okay.
He does.
And the evidence that he did not discharge that is her statements in 2 affidavits, I didn't understand.
Not just that she didn't understand, but I think that there's evidence that she did not have the capacity to understand. And that when you don't have the capacity to understand, clearly an attorney needs to render effective assistance in that type of case. And that's not what we had here.
I think we're gonna have to leave it there and hear from counsel for the child.
Thank you.
Good morning, Your Honors. May it please the court, Lynn Eisenman on behalf of the children. Your Honors, the children are supporting mother's request that this court reverse the order denying mother's motion for relief from judgment. One thing I will point out is that although the court did issue a memorandum of decision on the first motion that mother filed, that was filed with the assistance of counsel, but it was when counsel was withdrawing. We don't have a memorandum of decision on the motion for relief from judgment that appellate counsel filed. So one of the gaps is what information did the court? It was denied without a memorandum of decision, explanation or findings. And it was that motion that appellate counsel filed that included the neuropsychological evaluation and the letter from mother's therapist. So it's not clear what or how the trial court took that information into account in denying that second motion for relief from judgment.
Well, I mean, among other things, it's clear enough that the trial counsel or the motion judge, I'm sorry, did not consider it to bear or to require a different decision, right?
I think we read into that, yes, that she did not, but
and it's
I think
her
again
assessment of that I mean, among at least on second prong Safarian, we are also evaluating whether better work by counsel would have accomplished something material for the defense.
Correct, and I think in response to one of the questions, what evidence was there that mom did not understand, I think is evidenced by her going over to the DCF office the day that she entered into the colloquy or shortly thereafter.
Where is that in the record?
That's in the affidavit that was of mother that was filed with the motion from relief from judgment in November of 2019 that appellate counsel filed.
That's a very short affidavit, right? It's like a page.
It is, yes.
And in there she says, I went to the...
She says that she went to the DCF office and inquired as to when her mother could take custody of the children.
What's not in there is the statement that's emphasized in the briefs a number of times, which is, my lawyer told me that my mother was going to get the children. That is not in either affidavit. Am I right?
I believe so, yes.
Okay.
Right.
Also, one of the things about this case that I think we have to take into consideration is that unlike many cases we confront, this is a case where, at least according to the record, the judge lived with the case and the parties and counsel for years, and so would have been in a position much better than we are to assess credibility of the claims in the mother's affidavit and to have assessed counsel's performance during the colloquy and otherwise. How do we find an abuse of discretion given that sort of experience by the trial judge?
Well, so when this trial was happening, the parties were in on a motion for review and redetermination because there had already been a permanent custody order to the department. So what was submitted, I think one of the other problems is we don't have a full picture of all of the facts at the time of that trial day in June of 2019, because the only evidence that was submitted to the court were documents and records of the department, that some of which were more than 6 months old. So mother never was given an opportunity, which is not unusual when a stipulation is entered into and a colloquy is done. It is typically the department only that is submitting documents in support of the stipulation. But there was not a full evidentiary hearing where either mother or the children were provided with the opportunity to provide evidence to the court that may have made a difference. So she certainly did have a history. The trial judge did have a history with the parties. But in looking at the current level of mother's fitness at the time of trial, she did not have a full picture just because of the nature of presenting the stipulation.
Well, no, but the full picture of her fitness at the time of trial was really taken out of the case as an issue when the mother stipulated to termination. So the only question really that remains for determination is whether, I think, as I understand your principal arguments to be, the mother had the capacity to enter into that stipulation with competence. Right?
Right. But as far as going to the merits of mom's case and whether the motion for relief from judgment should be allowed, as far as the judge's picture on that issue, she did not have all the evidence that mother could have or should have presented had there been a full trial on that date.
Fair enough.
Was her filing timely under? In other words, was it in essence a timely motion for relief from judgment? You know, it's like 10 or 14 days, right? You got to get something on file. And I think it was 11 days. I'm just wondering if it was in that sense.
Well, I think under rules, if it's considered under Rule 60B, I believe it's timely. And appellate counsel's second motion would also.
I thought it was 10 days.
No, it's
on the 11th day.
It's months under Rule 60B. It's not the 10 days for Rule 59 motion. But it's also not as generous as the at any time as it is under Rule 30 in the criminal context. It's a bit of a Frankenstein mix to deal with ineffective assistance of counsel in these cases. But I believe the motion was timely.
And I don't believe that there's been any objection or any issue raised with respect to the timeliness.
No, there hasn't, but I was really just, I may be asking it for another reason, counsel.
Absolutely. I just wanted to address it. And I would say that on the last prong of reviewing the motion for relief from judgment, you know, because mother did file her motion shortly after the stipulation, and because appellate counsel filed her motion shortly after she was appointed, we have no delay here that's going to substantially impact the parties. These children want to go home to mom. They want to be able for mom to have a trial. And so on their behalf, again, I would ask that this court vacate the denial of the motion.
Can the children take a position against the motion? Well, let me put it differently. What was the position of the children at the time that the motion was filed back in June of 2019?
So I don't believe that there was a clear position taken. What counsel for the children at that time said to the judge and reiterated that the children want to go home, and was clear that had been their position for quite some time. There was not an opposition to the motion. It was not a joint motion either. Just a statement to the judge that the children did want to go home.
Because I saw a reference in the briefs to the child's counsel saying mom was fully advised and knew what was going on. Was that accurate or inaccurate?
That statement was made?
Yes.
That statement was made.
Okay.
Yes.
Thank you both.
Thank you.
For the department? You need to take yourself off mute, Attorney Bayless. You're still on mute.
I think maybe Kristen controls that.
No,
there we go.
no.
Can you hear me now?
Yes.
May it please the court, Jeremy Bayless for the Department of Children and Families. This is a case where two different attorneys and mother made a strategic decision to withhold the neuropsychological evaluation from both the department and the court. And now, after apparently regretting the results of the stipulation that mother knowingly and voluntarily entered into, are now trying to have this court undo that strategic decision. Two different attorneys, not just Attorney McDonald, but the court-appointed attorney prior to him.
Counsel, can I say, I'm not sure they're trying to undo that strategic decision. It seems to me to be much simpler than that. She changed her mind. She had a stipulation on June 6th, and sometime between there and the 17th, she changed her mind. She did not want to stipulate. And the issue that is sort of at the back of my mind is, when it comes to having your parental rights terminated, why is the department so heck bent on trying to prevent her from changing her mind within 10 days?
Because well, I guess my first response would be, specifically the child's counsel is trying to walk back that decision by arguing ineffective assistance by not providing the neuropsychological examination to the department. That was a substantial portion of that briefing. But as to your Honor's second question, the stipulation procedures only work if the stipulation is binding. If that is not a final solution, then sort of what's the point?
Well,
having
I mean, I agree with that, except if you change your mind, suppose she entered into that stipulation, she walked out of the courtroom, she said, darn it, I want a trial. And she'd walk back in 3 hours later. Would you be in the same position?
It would depend on how the trial court evaluated it. Now, do I think the trial court might have gone a different route had that been the case?
I'm actually asking what DCF would think under the circumstances.
If mother had stipulated and then come back, the same day and asked the trial judge to undo her stipulation, and the trial judge, being familiar with the case, did not do so, I can't speak for my supervisors, but I believe the department would be in the same position, because the trial judge is evaluating mother's demeanor. She conducted a lengthy colloquy and can determine whether or not there was some confusion, there was genuine remorse, all of those credibility assessments that go into whether or not
I'm
that's
asking a more fundamental question. I really am. I'm asking sort of basic fairness. She's given up an enormous fundamental right to have her children. She's done it voluntarily. She's stipulated to it. She changed her mind. At what point is that simply not okay? You say 10 days later, that's not okay. I'm asking, if it were 3 hours later, would you still be saying it was not okay? Because I'm really trying to understand the thinking of this. I mean, that's where we are. She gave up her children and she changed her mind.
Well, the difficulty is, Your Honor, that there has to be a bright line at some point. And the way it is set up is that bright line is at the time that the parent signs a stipulation, which is why there's a requirement that there be a colloquy and an investigation by the court as to do you understand what's happening, and are you making this decision of your own free will? If mother had, if parents, not the specific list mother, but if parents had some amount of time after the date of the stipulation, at which point they could change their mind, be it 3 hours, be it 1 day, be it 10 days, then it would just move that decision process to wherever that deadline is. It no longer is you have to have a colloquy understanding that, confirming that you understand the decision you're making at the time of the stipulation. It then becomes, well, it's your 1 day grace period. Now we need to determine at that point, and then parents can come back 2 days. And
let me just back things up for a moment here, though, because my understanding is that the mother is not making the argument that she has the right to change her mind. My understanding is that the mother is arguing that that she never agreed to the stipulation in a meaningful, legally binding sense in the first place. Isn't that the argument the mother's making here?
It is, Your Honor. And the sort of, I want to push back on both mother and the children's assertion of that neuropsychological evaluation as if it is 100% accurate and has been credited by any court of law. Mother worked as a certified nursing assistant in a nursing home. She testified that she had completed some college courses. She had her life history, as she has testified to it, calls into at least some question the degree of the severity of the disability that's laid out in that report. I cannot imagine how someone can function as a certified nursing assistant if they are unable to read and process information to the degree that it's being alleged that mother is now. And it would certainly be a reasonable inference that a judge, being aware of that information, having watched mother conduct herself through a trial and observed her through years of proceedings, might not be inclined to fully credit that.
Let me though push back a little bit on one procedural element of that. As I understood the presentation from your sisters, the judge was not presented with the neuropsych evaluation until the second motion, the second 60B motion filed by appellate counsel. Was there a hearing held on that motion?
I do not believe so.
Okay, so that then we get into the question, again, drawing from the criminal analogy, the new trial motion, of whether there was a sufficient showing to warrant a deeper inquiry. It's one thing to say that the neuropsych evaluation did not establish that she was incapable of understanding, but did it raise a question warranting inquiry at an evidentiary hearing, or was the judge acting appropriately in denying that motion without an evidentiary hearing?
I believe the judge was acting appropriately. The judge had sufficient information based on the colloquy and experience with the case to determine at the time of the stipulation that mother was competent to make that decision. The judge was not required to, and this goes back to my initial point, that the strategic decision to withhold information from the court, the judge was perfectly entitled to determine that that was, well, there was no need to go into more detail on that information once it was brought to light later.
I think the strategic decision is a bit of a red herring, I have to say. It seems to me that the central question here must be whether the mother had the capacity knowingly and voluntarily to enter into the stipulation, regardless of whatever strategy may have underlay the obfuscation from the judge of her incapacity. So the real question is, was she capable or not? And to the extent that the new trial motion, motion for relief from judgment, presented the judge with reason seriously to question that, the question is really what level of inquiry was the judge required to conduct? You say that it was enough for the judge to review the report and to reflect on her experience and observation of the mother and determine whether or not she held a serious concern, whether the mother was capable or not. And I understand that argument. Another argument might be that the judge should have expressed that view in a written memorandum of decision explaining her rationale rather than simply denying it. It might be that the judge should have given the parties an opportunity to cross-examine the expert or to present evidence on the mother's capacity. I don't know, but those are just, I'm just sort of throwing out questions about the procedure that was followed in this case.
Well, I can't speculate to great extent as to what was going on in the judge's mind, but I could certainly envision a scenario where mother has participated in the proceedings without giving any indication that she had cognitive disability to the level that she's now arguing in her second motion to set aside her own stipulation. Two attorneys have had access to a report and chose not to provide it. The evidence before the court is that mother herself has told the department that she was looking for a second opinion in the neuropsychological evaluation. That bears to whether or not mother and her counsel even found that this was an accurate reflection of mother's ability that is only being brought to light now in an attempt to undo a decision that mother made.
But that leads to the question of whether there should have been an evidentiary hearing. I understand the point, counsel. Can I ask, in November, when they filed the second motion, the judge held a hearing?
I don't believe the judge did, but my recollection is a little hazy.
So there was no hearing on that. Was there an opposition from DCF at that time?
I believe there was.
And no ruling whatsoever except denied. Okay.
But when determining whether or not mother was competent to sign the stipulation, we have present time testimony from her that she was. She engaged with the court in the discussion, despite being emotional. When she made a misstatement as part of the colloquy, as my sister points out, she corrected herself, indicating that she understood what she was being asked. She spoke too quickly, walked back the answer she gave, and gave the correct answer. Her own behavior indicated that she understood what was happening. And the attorneys that were present at the trial, even the ones who were not necessarily supporting the denial of mother's motion, the child's trial counsel even affirmatively stated that mother had had a significant amount of time to prepare for the hearing. This contention that mother was incapable of understanding what was presented to her only arises well after the fact.
Well, yes and no. And I return to the questions I was asking your sisters. I mean, yes, the neuropsych really doesn't, well, it's within 10 days. It's within 10 days, the mother files her own pro se motion, fires her lawyer, files her own pro se motion, in which she mentions that the neuropsych evaluation obliquely. She says, Dr. So-and-so said such and such, right?
Well, the basis of mother's, I mean, she obliquely mentions it, but what she says is my lawyer did not explain it to me. Not I didn't understand him, but he told me things that weren't true. And the only evidence we have as to that point is we've gone over is the affidavit from the attorney provided with the motion to withdraw, which also
doesn't say anything, right? It's just like one, I just read it, I think. It's only like 3 sentences.
Yes, it's very short. It references that he explained it to her and that he information came to light that would have created an ethical dilemma in representing her. We don't know what that means.
It's one could speculate that it's that she's going to accuse him of misrepresenting things.
Yeah, there's a root of ways. Yes, Your Honor. But the easiest answer is that mother gave a coherent explanation in colloquy that she understood what was happening. The judge who had observed mother watched her, understood what was happening. Mother's record indicates that she can at least understand some college level courses which require reading. There's ample evidence in this record to demonstrate that mother was competent when she made the decision to stipulate to the termination of her parental rights. And if there are no further questions, I'll rest on my brief.
Seeing none, that will conclude the argument in this case. We are live.
Excellent. We are live and on the record.
The sixth and final case on our list for hearing today is case number 2020P142, Susan EDIC versus Christopher EDIC. Case on our list for hearing today is case number 2020P142. If one of you has the YouTube on in the background, please mute that. If one of you has the YouTube on in the background, please.
Can you hear me, Your Honor?
Yeah, did we get it muted?
It is muted. I apologize. I was watching your prior argument.
Okay, that's quite all right. We've learned that is the culprit when we hear the echo. So you may begin your argument, Mr. McMillan.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the court. This is an appeal out of a judgment issued by the Probate and Family Court in Essex County with respect to modifications of both a parenting plan as well as child support obligations. The underlying divorce actually took place up in Brentwood, New Hampshire back in February of 2016. And the divorce was actually issued by agreement of the parties. They worked out a parenting plan and the child support. That decree was recorded with the Essex County Probate and Family Court in February of 2017. And the subsequent actions were initiated as a result of a letter from my office to the refer to the dad as Christopher, asking for payment on health insurance as well as for his financial information with respect to his income for W-2s and 1099s and the tax returns as required by the uniform order issued by the Brentwood Family Division.
Mr. McMillan, can I jump in with a question and perhaps leap forward to the issues that are before us? If we credit the judge's findings that the children wanted to spend more time with their father and the father had greater flexibility in his new job and therefore could spend more time at home, why aren't those changed circumstances that would support a best interest determination?
Well, if those facts were true, then it would support that, Your Honor. But unfortunately, there's no evidence before the court that would support that particular contention. First of all, with respect to comparing the two jobs, back in 2016, when Christopher was getting divorced, although he was employed, he had taken a leave of absence. So he had more time, not less time, with respect to spending time with the children. The parenting order that he ended up working out through the court system was the one that was actually presented to this court and recorded back at the Essex County Probate and Family Court in 2017. What has changed since then is that Christopher ended up getting a job in October of 2017. And the job that he ended up getting was with a company that is based out of San Francisco, California. I believe it's called Coventus. And what he is essentially a loan officer. And since his employment in 2017, he's had less time, not more time.
Counsel, if I might, can we just back up for a second? In response to Justice Kinder's question, you said it would, but there is no evidence in the record to support either finding. And now it seems to me you're arguing fact. Is it your contention that Christopher did not testify that his time was more flexible, or that Christopher did not testify that children would like to spend more time with me?
I don't think that that's adequate evidence, Your Honor.
Why not? The judge has the prerogative to make credibility determinations, right?
Yes, she does.
Okay.
But unfortunately, the only witnesses at time of trial were the father and the mother. The children were not present at the time.
Did anybody object on grounds of hearsay when he so testified? My understanding is he testified the children would like to spend more time with me. When he did so, did anyone object on grounds of hearsay?
Well, I don't recall that being the testimony. I think his testimony was, and in fact, it's referred to in the father's brief. He refers us to page 325 of the record appendix, in which he says, I believe I should be split as equally as possible, you know, assuming the situations allow for that. But there are no issues with the time that I've had with the boys. I just think that, you know, I definitely want more. And my impression is that they want more as well. So
That's the entire evidence on that score?
It is for, nothing else was quoted in the brief for the appellee, Your Honor.
Well, it's not the question of what's in the brief, it's the question of what's in the record.
I don't recall anymore in the record. I recall that there was more time spent, that the changes that I believe Mr. EDIC ended up testifying to were something along the lines of he's got flexibility in his job, that he's involved more with the boys, things of that nature.
So he did testify to having more flexibility in his job?
Well, that's what his testimony was.
Well, you know, the judge can accept that, right? And in fact, so found, didn't she?
Well, here's the problem, Your Honor. What he says and what is actually proved by the facts are two different things. He said that.
No. What we accept the judge's findings of fact based on the evidence in the record, except when they are clearly erroneous based on the evidence in the record. What record evidence can you point to establish that the judge's finding of fact was clearly erroneous?
Well, what I would point to, Your Honor, is the fact that, again, at the time that he got divorced and he negotiated his parenting plan, he was, although employed, he was on a leave because of stressors involved.
Where is that in the record?
I don't have it readily available at my my fingertips, unfortunately.
Okay, and the accepting for a moment that he was on a temporary reduction in his hours, it was certainly appropriate for the judge to establish a forward-looking parenting plan based on his regular work schedule when that temporary adjustment came to its conclusion, correct?
I would agree.
Okay, and going back to Justice Englander's point, at the modification trial, the judge received testimony saying that the husband had more time available at that time than at the previous time. That the judge made a finding consistent with that, right?
No. Excuse me, Your Honor.
No, is that correct?
I don't recall that that's what the testimony was, okay? It dealt with flexibility issues, not that he had more time available.
Well, okay, more flexibility.
All right, so looking at his employment, though, is his new employment, in which he's dealing with a company that is based out of San Francisco, and based on his testimony as well as the testimony of the mother, he had, I think, less flexibility, not more flexibility. He traveled as part of his job. He's got a job in which he goes in and out of Boston on a regular basis. And
that's certainly you can certainly make that argument to the trier of fact. And the trier of fact has to assess the competing strands of evidence and make a conclusion as to whether his schedule is more or less flexible in order to sort out the respective positions of the parties. The judge made a finding, right?
Judge did make the finding, but I think it belies the fact. He's got a job now where he's...
That's the same thing as saying, I think it's clearly erroneous, right?
It is.
So,
okay.
So I guess we're back to the same place where we need to have, if you're going to argue that the findings were clearly erroneous, we need to have the record evidence that establishes them to be clearly erroneous.
Can I, I'm sorry, wait, if you want to take time to, okay, go ahead.
Well, I referred to circumstances in the brief that involve things such as the travel that he's got to do going back and forth to work. in and out of Boston. He's 6 or 7. He works till 6 or 7 at night. He travels at least once a month, and that could be anywhere between 1 and 3 nights. The testimony at time of trial was that in 2017, he spent 30 days in California for training and whatnot. But during that 30-day period, then mother had to pick up all the slack. In 2018, he took between 8 and 12 trips.
Counsel, finding number 12, the court credits father's testimony that his work schedule is more flexible, allowing him to leave for work later in the morning, work from home, or choose which days he has to go to Boston if he has the children. Clearly erroneous?
Well, I guess I will backtrack a little bit on that. It's not clearly erroneous because
finding number 14, father's more flexible work schedule allows him to parent the children on the additional overnight, and the children would like to spend more time with their father.
But that's unsupported. I don't recall anything in the testimony in which the statements that the children said that they want to spend more time with the father. I did refer the court to a testimony.
Didn't the father testify to that?
What's that?
Didn't the father testify to that?
Well, he testified that it was his impression.
Well, that's the only evidence that exists, right?
Yes, in my opinion.
Can I ask another question? Your first argument, and I think this is the argument we're still on, is there was no basis for finding changed circumstances under the statute, and under the statute, changed circumstances were required, right?
Yes.
Okay. Mom got more money in child support. I assume that you argued for more child support on the basis that there were changed circumstances. Am I right?
Yes, but changed circumstances from the beginning when the order was initially issued by the Brentwood Family Division, in which the father's income was substantially different. It's triple.
Okay, so there was a changed circumstance. Father's income has changed. It's changed as the result of getting a new job. Is it your position that it's changed circumstances for your client sufficient to modify, but not changed circumstances for the father sufficient to modify the custody arrangements?
Yes, it's because it's my contention.
Got any case that says it can be changed circumstances for one component and not changed circumstances for another component of the same work?
I apologize, Your Honor. They're two separate issues, and they're initiated by two separate complaints for modification. And I don't think you can bootstrap one on the other. So,
but you say I don't think, and my question was, do you have any case law? Because see, my sense from, and I didn't practice in your area, counsel, but my sense is that very often the various parts of these orders in a divorce case are interrelated in some ways, right? Somebody gives a little bit of this, they get a little bit of this, and they all come to an agreement. You're agreeing and in fact arguing that there were changed circumstances with respect to one component of what was the baseline for the earlier order. Isn't that sufficient for that to reopen other issues as well?
Well, the changed circumstances I'm arguing, at least on behalf of the father, don't support a increase in parenting time for him. Quite the opposite, because he's got less time to spend with the children because of his traveling schedules. His job takes him in and out of Boston, and so on and so forth.
I want to shift gears if I can, just because we've been over this quite extensively, I think, and we're coming close to the end of time. One of the other arguments that you make is an abuse of discretion for the failure to enter the party stipulation regarding health insurance in the decree. The decree entered before the stipulation was presented to the court. Did you present the stipulation? Did you present a motion for modification of the judgment to the trial court?
No, but if I could just back up, Your Honor, we addressed the issue with respect to health insurance twice.
I know, I understand that, but when the decree came out and didn't reflect the stipulation that you had hoped it would, why in the world did you not go back to the judge in the first instance with a request that she modify the decree in order to incorporate that judgment? Why are you bringing that to us?
Because the judge did not live up to the 21-day period for us to file. I filed the stipulation timely, and she cut it short. We were supposed to have.
She finished her work before you finished that, but I mean, I understand the how it happened. What I don't understand is why she wasn't given the opportunity to address the concern before you present it to us as an abuse of discretion.
I don't think
you couldn't have incorporated the stipulation that she didn't have.
Well, she did have it because it was emailed to her clerk 2 days later, and it was signed, Your Honor, not only by myself from a signature basis, but it was also signed by Attorney Gleason as well.
But that was after the judgment already entered, correct?
Yes, it turns out that the judge gave us about 3 hours to respond to an email from the clerk, which was insufficient time.
And what you did send did not give her any detailed information about additional cost to cover the children or what the coverage for the children would be, correct?
It did give the cost right in there. It was $200 per month.
No, it said that was the cost for the father's health insurance. It didn't talk about what the children's additional coverage would cost, right?
I believe that was the additional cost for the children.
All right.
All right.
Thank you.
Thank you.
Attorney Gleason.
You're on mute.
You're still on mute, Attorney Gleason. You have to take yourself off mute.
Sorry, Your Honors. Your Honors, I think it's worthwhile taking a step back a little bit and looking at some of the other facts that came out in this trial, because I think it's very, very instructive in terms of giving some insight into what the court's, trial court's thinking process may have been when it was considering this matter. Both counsel, we were in the very atypical situation and positive situation where we were first dealing with two what were acknowledged to be on the record by both parties, happy, healthy children. And we were also dealing with a situation where the parties, although they had had what could be characterized as a high conflict divorce, is that their communication had actually improved quite a bit. It wasn't during the modification period, but it improved over time quite a bit. The father had, the children were older. The father had extensive involvement in their school and extracurricular activities. And probably most importantly is that we were only requesting what ended up to be a minor change in the custodial arrangement. And in terms of the courts reviewing these things, as I understand the case law, and I've tried to set it forth in my my brief, is that when you're dealing with the situation of visitation, it's different than custody to a certain extent. And in terms of what you're dealing with in visitation, it depends on what you're looking for. When you talk about these standards that you have to meet relative to specific and detailed change in circumstance, material and substantial change in circumstances, and what is the best interest of children. And just to quote from what I cited in my brief is that these visitations, quote, run the gamut from minor schedule adjustments to extensive changes in parenting time and the children's schedules. Each case must be decided on its own peculiar facts. The change of circumstances must be of sufficient magnitude to satisfy the governing principle by which the court must be guided on these cases.
So counsel, if I might, counsel, you agree that the statute requires changed circumstances, right?
Yes.
And your brother takes the position that the changed circumstances had to do only with those facts that relate to the party's ability to do visitation. So I want to leave that problem aside because he admits there were changed circumstances and the fact that your client was getting more money. Now, if he's right that we should only be looking at those facts that bear on visitation, what's different between when your client signed in 2016 and 2019 that would suggest that your client should get more visitation rights? In 2016, your client is out of a job. And now 3 years later, he says, oh, circumstances have changed so that I should get more visitation. And what is it that's changed?
Well, I think, Judge, that first of all, he wasn't out of a job. With due respect, Judge, what the record indicated is that he was on leave from his job. And as the court, when I'm sure noticed when you look through the record, is that during the divorce, he was issued a child support order. I believe it was $357 maybe every other week. So clearly, the evidence is that although he was out of work, he was earning an income. He was on leave. So in terms of the evidence, Judge, is that if
so along with that comes a baseline as to what his job was like at the time, is your point, and right?
Correct.
The baseline. Okay.
Correct. And I would agree. You're not going to find anywhere in the record what his work schedule was at the time of the divorce. That I can't find it in the record that was ever done. But what you can find in the record is you can find it's, I believe, at page 232, 293 to 297, 328 to 329, and 352 to 353. I believe that you will find that he makes a detailed description of how it is that his job is different today than it was in the past. He doesn't describe what the job was in the past, but he describes differences in his work, and those are all incorporated into paragraph 12, where the judge is making the factual conclusion.
Mr. Gleason, can I interrupt with a question?
Sure.
On that point, just to be clear, the change in parenting time that we're talking about before the modification judgment and after the modification judgment is 1 overnight per week additional, correct?
It's a little bit more than that, Judge. It's you taking every other weekend, the Friday to Sunday, and you're extending that visit, that every other week, that Sunday night into Monday morning. And then you're taking the visitation that he had during the week. I believe the court or the divorce was originally Wednesday to Thursday, and by the parties' agreement, they made it. They had been doing Thursday to Friday. You're increasing that by 1 overnight. And the way the judge looked at it, I believe it was in one of her footnotes, is that he had not been exercising a Monday night visit that he had been given in the divorce, and that was not an overnight. So she felt as if, I think she says it somewhere in her decision, that she was just giving him back something he already had, and extending it overnight. So it's really the schedule changes here are minimal, and I think what the decisions.
Well, it's 2 more overnights a week when he has the weekend.
Yes.
Instead of having 5 overnights, he has 7. I'm sorry, that's not at all what I meant to say. Instead of having 2 overnights, he has 4.
Yes, it gets increased by 2 on the weekends that he has the children. But again, Judge, in terms of when you're looking at,
kind of significant to me.
Well, I think, Judge, if you look at the other facts, and my view would be is that it's not really that significant, because you're dealing with, the evidence was clear, the children's schedules aren't changing at school.
The question isn't so much that whether the change was significant in the parenting schedule. The question is whether there was an adequate change to justify reopening the question at all. If there was a material change in circumstances, then we'd conduct the examination to see what's appropriate, and the change could be, in fact, quite radical if a radical change is warranted. So it's the fact that the change was modest doesn't really bear one way or another on whether it was appropriate. The threshold question is whether there was a material change in circumstances warranting a reexamination.
I agree, Judge, and that's what when I was quoting that language. When I read the language of the cases with visitation, and they talk about that gamut that runs between, a minor scheduling change to something more significant, is that it seems to me that they're deciding that the change in circumstances is a fluid thing, and it's really fact specific.
Well, yes, but by the same token, it ought not to be so de minimis as to have the parties running into court for judicial review every time there's a minor change, right?
I agree with that, Judge. And so I agree that that's something that the court has to bear in mind. But I would also suggest that it seems to me that what the cases are saying with this fluid concept of when do you have a change in circumstances is I think what they're saying is that when you're seeking a minor change, the change in circumstances doesn't have to be so great as it might be if you're making a major change. That's how I'm reading the language.
But still, it's a threshold issue.
It is, Judge.
Justice Green is saying it's statutory requirement, and the reason is exactly what Justice Green identified. I think that you need some kind of finality to these orders, and if anything will allow you to reopen them, that you could be spending all your time on modifications.
Right. So I think, Judge, if you go to paragraph 14, the judge is citing father's more flexible work schedule. That's previously been recognized by this court as a legitimate change in circumstance, generally speaking, and it was his change in his work schedule was described in detail. That he had more control over his work schedule. That he could go into Boston later in the day. He chose the days he could go into Boston. He could work from home. He could arrange his any travel that he had to do. He had much more flexibility, and the judge adopted that. And secondarily, the judge doesn't stop there. The judge says not only the flexible work schedule, but that the children would like to spend more time with their father. And I believe that it is.
What was the evidence to support that latter point?
In my brief, Judge, I cite to there's the appendix at page 252, and the evidence is that father testified that that's what his view of what the children's desires were.
Page 252 of the appendix is the judge's finding. I'm asking for what the evidence was to support that finding.
What did the father say?
I can get the correct site. I'm sorry. It was appendix at 325. 325. I'm sorry. And at 325, it's the father's testimony where he says that the children, or words to the effect of the children like spending more time with me or want to spend more time with me.
It was the exact testimony what your brother said. I have the impression they'd like to spend more time with me. What is the exact testimony?
Judge, I don't have the appendix in front of me.
I can tell you, I can read it to you. It says, I believe time should be split as equal as possible, assuming the situations allow for that, but there are no issues with the time I've had with the boys. I just think that, I definitely want more, and my impression is that they want more as well.
Then that's what it is. But I think that when the judge credits that, she's entitled to credit it. She's crediting it in view of the other testimony and evidence in the case where, for example, the father
Mr. Gleason, I think we've exhausted that particular point. Before you run out of time, I'd like to ask you a question about child support, which your brother suggests should have been made retroactive to the point that his client's motion for modification was filed. And we have a case, 2009 case in this court where we suggested that although it's not mandatory, modifications of child support in these circumstances should be retroactive unless there are specific findings made by the judge that it's unjust or not in the best interest of the children. I didn't see any findings in this case. Were there any?
I don't recall seeing any findings on that issue, Judge.
All right, so why wouldn't Whalen, which is the case I'm referring to, why wouldn't that control in this instance?
Well, I think that, first of all, it's up to the appellant. If the appellant is raising the issue, I think the appellant needs to make that argument and develop that issue.
The appellant has made the argument, they haven't cited the authority, that's all.
Well, but the issue hasn't been developed in terms of, so that at least
that's what Justice Kinder's trying to do. He's saying to you, there's this case I'm aware of. Now, why shouldn't I follow that?
Well, I think, Judge, that I certainly appreciate that, but I think in the first instance, it's up to the appellant to bring up that issue so that I can properly address it in my paperwork and here today. But I would say that what I know is the facts of the case, and what I know of the facts of the case is that there wasn't any issue about my client's failure to pay child support. He's always been current on his child support, I believe the evidence was. So I know sometimes in my experience that that's a factor that courts look at is are we dealing with a situation where somebody is, recalcitrant on paying their child support, or are they obeying court orders? That was never an issue on the child support. That's the only argument I have on that. And with that, I just rest on my brief unless there's any other questions.
Seeing no further questions, I will thank you both for your arguments. That concludes our session. I want to give special thanks to our session clerk, Kristen Nagel. These are not easy sessions to clerk on Zoom, and there are many, many more tasks that the clerk needs to address, and she's done a terrific job for us, and we